received is the competence to waive the right to counsel and represent oneself, which is from Chapter 7 in the textbook, Psychological Evaluations for the Courts. In order to understand the concept of whether an individual is competent to waive their right to counsel and represent themselves is to understand the term of decisional competence. The definition for decisional competence is the competence to make a particular decision, as well as the state should not invoke parens patriae, which means that the state would not care for the individual unless the individual lacks capacity to make a specific decision or perform the specific act at issue. Now, the issues that could follow within decisional competence can rely within criminal litigation competence to consent to search and seizure, competence to exercise and waive their right to avoid self-incrimination, competence to enter a plea, competence to waive their right to an attorney and represent oneself, and competence to refuse an insanity defense. On the next slide, I will be discussing the main topic of the competence to waive the right to counsel and represent oneself. According to the textbook, the following all play a role in whether an individual is competent to waive counsel and represent oneself. To start with, the decision that increases an adverse effect with the defendant achieving a fair trial due to depriving the defendant of a legally trained advocate. When a defendant voluntarily goes to trial without counsel, then a defendant will be assessed based on their ability to carry out basic trial tasks. Now, these basic trial tasks can consist of the defendant being able to communicate with counsel, testify relevantly, and provide rational reasonings. To waive counsel, then they are likely permitted to proceed without counsel. As well as, in a typical competence evaluation, there is usually no evaluation for waiver of counsel and self-representation. It can be suggested that clinicians should first conduct a standard competence to proceed evaluation that is supplemented with inquiries on whether the defendant knows the disadvantage, as well as the clinician should assess a wide range of cognitive functions such as concentration, reasoning, and communication capacities, since the courts have not identified a uniform definition or legal test for determining when a person is competent to proceed without a counsel. With understanding the competence to waive counsel and represent oneself, a defendant is not likely to be found incompetent if they choose to proceed pro se, which means to represent themselves due to the beliefs that they can do a better job than the attorney, think that the lawyer will not effectively communicate their message, or disagrees with the counsel's objectives, unless the defendant's reasoning is rational. On the other hand, examples of the defendant being found incompetent in the following situations consist of defeatist attitudes, which an example from the textbook is a lawyer won't be able to help because I'm guilty, paranoid ideation, which an example from the textbook is all lawyers are against me, as well as fantastic objectives. An example from the textbook is the defense based on the assumption that a murder victim is not dead. And lastly, irrational beliefs, with an example from the textbook being supernatural powers will prevent the jury from returning a guilty verdict. The first Supreme Court case that had a significant impact on the topic of competency for an individual to waive their right to counsel and represent themselves is Ferretta versus California. Starting with the Supreme Court rule that the Sixth Amendment guarantees the right for defendants to represent themselves, as well as Justice Stewart declared that procedural rights of due process belong to the accused, not the counsel. However, this court case did not define competency to waive counsel, rather it defended the right for the individual to represent themselves during trial. And lastly, the court case emphasized that the defendant is not incompetent to waive counsel due to not comprehending hearsay rules, which would mean outside evidence coming in for the trial. On this page is a brief paragraph from the Sixth Amendment that was taken from the textbook that just states that the Sixth Amendment speaks of the assistance of counsel and an assistant. However, expert is still an assistant. The language and spirit of the Sixth Amendment contemplate that counsel, like the other defense tools guaranteed by the amendment, shall be an aid to a willing defendant, not an organ of the state, interposed between unwilling defendant and his right to defend themselves personally, meaning that it gives the right to the defendant to choose if they would like to waive the right to the counsel, not for the counsel to make that decision for them. In addition, Another Supreme Court case that played a role in this topic is Competence versus Moran, starting with that the court declared that competence to stand trial and plead guilty are equivalent to one another. From this court case, the majority stated the competence that is required of a defendant seeking to waive his right to counsel is the competence to waive the right, not the competence to represent himself, as well as the trial judge moving from must deem that the waiver was voluntary and knowing, meaning that the defendant was made aware of the disadvantages for themselves if they chose to self-represent. And lastly, the court may inquire the defendant's reason to waive, and they must deny the waiver if the reasons are irrational. On this slide is the media that I incorporated with this topic, which is a video of a court trial that took place about 2 years ago, and it shows a great example from the court case Competence versus Moran with the idea of invoking your Sixth Amendment during trial to take away from having your counsel representing you and choosing to represent yourself. The defendant in this case is Trevor Summers, which on the second day of his trial, he chose to invoke his Sixth Amendment during mid-trial before they were going to recess, and his counsel informed the judge that his client wanted to represent himself and that he would step back and be a standby counsel, which would just mean that he could provide advice to the client upon their request. The judge then spoke with the defendant, who explained that they felt like they could represent themselves and had different objectives than what his attorney did, and that he could explain the case in further depth. The judge then granted for the defendant to represent himself, and ultimately ended up waiving his right to counsel and representing himself for the rest of the trial. The third Supreme Court case that had a significant impact on this topic is McCaskill versus Wiggins, starting with if the defendant does waive counsel and proceeds to trial, then the trial court is authorized to appoint a standby counsel. In addition, the court declared that a defendant who waives the right to counsel cannot be forced to proceed with counsel as long as the defendant retains control over the case presented to the jury and the jury understands the defendant is representing themselves. And lastly, within these conditions, that standby counsel can provide the pro se defendant advice about tactics and legal rules, meaning that if the defendant chose to waive their rights to a counsel, then this other counsel is obligated to stay with them and provide advice if the defendant would like it. The last Supreme Court case that played a significant role in understanding the topic of the competency for an individual to waive their right to counsel and self-representation is Edwards versus Indiana. Firstly, 14 years after Competence versus Moran, the court held that defendants who are competent to stand trial and waive counsel may be required to accept counsel if they suffer from severe mental illnesses to the point where they are not competent to conduct trial proceedings by themselves. However, within this court case, the court declined to provide clarification on whether a defendant who is competent to waive counsel is incompetent to represent themselves, which still appears to be a question to whether if an individual is competent to waive counsel, are they competent enough to still represent themselves during trial? Therefore, this leads to the discussion question for this topic, which is, can a defendant who is competent to waive counsel still make decisions that compromise their defense or outcome? And to further depth, explain how a defendant's right to self-representation may lead to strategic or procedural issues within the case, even if they are found competent to waive counsel.